Does it make a difference if this sanction was imposed in a separate proceeding?
Does it make a difference if it had been imposed outside of the sentencing context? Well, I don't think it would change the nature of restitution as punishment, given that Congress refers to it as a penalty, but it might change whether we conceive of it as a civil penalty, like the administrative penalties at issue in Hudson or in Ward, or whether we consider it a criminal punishment. The fact that this penalty is imposed in a criminal proceeding is one strong indication that it is meant to serve as criminal punishment.
Do you think that all sanctions imposed in criminal proceedings are in fact penal or criminal?
So I think this is an important distinction, Justice Thomas, and I want to be clear that we do distinguish between what is part of a criminal sentence and what occurs at criminal sentencing, because we agree with amicus that not everything that occurs in criminal sentencing or even that appears in a criminal judgment is necessarily part of the punishment and therefore part of the criminal defendant's sentence. So the classic example here would be the registration requirements at issue at Smith versus Doe, because those requirements were announced at sentencing. They even appeared in a judgment, but that didn't make them part of the sentence because they weren't meant to add to the defendant's punishment at all. So here it is quite important to our analysis that Congress has specified that restitution itself is meant to serve as a penalty or a sanction.
In a recent courtroom discussion, justices grappled with a fundamental question. Is restitution a punishment or simply a civil penalty? The debate highlights the complex boundary between criminal and civil law, and how Congress defines justice in monetary terms. The exchange began with the question of whether it matters if a financial sanction is imposed during sentencing or in a separate proceeding. Legal experts argued that while the context might shift interpretation, the nature of restitution remains the same. Congress itself refers to restitution as a penalty, which points strongly toward its classification as a form of criminal punishment. The speaker noted that because restitution is imposed within a criminal proceeding, it carries the hallmarks of a punitive measure rather than an administrative or civil one. Still, the debate took an important turn when Justice Thomas raised whether all sanctions in a criminal case are automatically criminal in nature. In response, the argument clarified a vital distinction. Not everything that happens during sentencing is considered punishment. For instance, requirements like offender registration, though announced during sentencing, are not meant to add to the defendant's punishment, but to serve administrative or protective functions. Takeaway: Congress's intent is the deciding factor. Since restitution is explicitly described as a penalty or sanction, it must be treated as part of a defendant's criminal sentence, not merely a civil consequence. This discussion underscores how the legal system continues to balance fairness, accountability, and the boundaries of punishment in America's justice framework.